Good afternoon or good morning, depending on where you are today. Welcome to the Fasken Pension and Benefits Look Forward and Look Back. My name is Gascho. I am the practice head of the Pension and Benefits Group and located in Toronto. Joining me today are my colleagues, first in Calgary, Michael Wolpert, and our newest member of the group, Lindsay, and in Montreal, Dominique Monet and Rhonda Grintuch. We have a lot to get through, so let's just jump right in. As you probably saw, if you have questions, please post them online, and we will get to them at the end, time permitting. In terms of speaking order, I'm going to kick it off, followed by Michael Wolpert, and then Lindsay, and then together Rhonda Grintuch and Dominique Monet. I want to speak first about an issue that applies to federally registered plans and those plans registered in provinces that use the federal investment regulations, most notably Schedule 3 under the PBSA 1985. And that is the 30% rule. Pension fund investments are subject to what's known as the 30% rule. That's the rule that prohibits the administrator from investing the plan's money in securities of a corporation to which are attached 30%, more than 30% of the votes to elect the directors. On December 15th, the government announced that it would revise the 30% rule and eliminate it for investments on what it refers to as Canadian entities. The purpose is to encourage greater investment in Canada. The 30% rule has been around for a long time, and there have been developed over that time various strategies that are intended to permit a plan administrator to comply with the 30% rule and at the same time hold an economic interest of more than 30%. So we don't know yet if this is going to be a significant win for plans. For those of you with federally registered plans, the government also released draft regulations that would require what it calls large plans with more than $500 million in assets, to disclose your investments both by jurisdiction and asset type. The ostensible reason is to help members better understand their investments. But the development seems to be tied to the fall 2023 economic statement, in which the government suggested that it was time for pension funds to invest more in Canada. This regulation, although it would technically apply only to federally registered plans, we expect that the federal government will seek the provinces to also enact similar measures. And it will apply to plan years going back as far as 2022. And finally, for federally registered plans, the regulations to enact solvency reserve accounts have also been released. Solvency reserve accounts try to solve a problem in solvency funding, which is that the plan can move quickly from deficit to surplus, and the solvency funding payments are then stranded as surplus. Solvency accounts are essentially a side account to a pension fund that when the plan moves into a sufficiently funded position, the solvency contributions can be withdrawn to the extent permitted without going through the surplus withdrawal rules. The reason for using solvency reserve accounts is because the federal government believes that employers will fund solvency deficits more quickly if they are aware that the money can be refunded if the funded position improves. The question in all three of these is, well, what's happening with these given the political situation, in particular, the possibility that the government will fall and that we will face an election? The short answer is we don't know, but because these are regulations, Cabinet still operates, so it's possible that the government could finalize them in advance of an election. Let's move to Ontario and the Financial Services Regulatory Authority. These folks have been busy. I want to talk about three documents that they've released in the past year. Before I do, it's important to understand where FSRA is coming from. And that is, we look to their statutory objects, their mission, and their framework principles. Their statutory objects for the pension sector include, of course, regulating the pension sector, but also contributing to public confidence in the pension sector, promoting good administration of pension plans, and protecting and safeguarding members' pension benefits and rights. FSRA's mission is public service through dynamic principles-based and outcomes-focused regulation, and its framework principles notably include what it calls accountability, which is that regulated persons have to have in place controls and processes to appropriately meet the expectations that are set out in FSRA's guidance. The first of these documents is principles-based regulation. This is an approach. So it is FSRA's internal principles. The document is not unique to pensions. It applies to all of the sectors that FSRA regulates. Essentially, it provides that an entity has to be able to demonstrate how it adheres to principles that FSRA has put forward. The idea of PBR, or principles-based regulation, is that compliance with highly detailed requirements might ultimately miss the mark, given the various unique situations that everyone faces. And instead, that by articulating principles, it provides for a more effective regulatory structure. The second document is administrator roles and responsibilities. This is an interpretation. In other words, this is FSRA's view of the law. And it largely follows what their predecessor had put forward, but perhaps stated more stringently. The administrator is responsible for implementing processes to ensure that risk is understood and controlled. In using service providers, they point out that the administrator remains responsible for a service provider, and that the service provider cannot contract out of the standard of care. They're concerned about supervision of service providers, in particular the reporting obligations, and that the use of the service provider is permissible, provided that there are established policies that the administrator can review and monitor. The administrator's role includes records retention, even though the provisions for it were removed from the legislation. And finally, and most importantly, FSRA states that a governance framework is mandatory for all pension plans. And that's a framework that assesses potential risks, including the plan's ability to absorb future contribution fluctuations. And finally, FSRA's pension plan amendments interpretation from last year sets out what amounts to a new type of amendment. And that's what they call a retroactive adverse amendment. That's an amendment that may negatively impact member rights or benefits, and that purports to be effective on a day before the amendment was filed with FSRA. A retroactive amendment has to be able to demonstrate no adverse effects. In other words, that there are immaterial impacts on member rights and benefits, and that the impacts are offset by the facts of the situation. So, for example, a negotiated amendment or an amendment arising out of a corporate reorganization that was previously announced to members. FSRA asserts that it has the discretion to register or not register a retroactive adverse amendment based on circumstances. The various drafts of this interpretation triggered a lot of discussion with the pension bar. And I'll say that if you take one thing from what I say today, it's that if you're going to file an amendment in Ontario, file it before the effective date. And it's important to note as well, for those of you without Ontario registered plans, that these changes or this different view that FSRA is promulgating didn't require a change in the legislation. The PBA sits as it did previously. So it's possible that your regulators could take a similar approach. And now I'm going to turn to CAPSA, the Canadian Association of Pension Supervisory Authorities. This is the umbrella organization that is all of the pension regulators across the country, and their documents reflect a consensus view of the organization. In 2004, CAPSA released something called the Capital Accumulation Plan Guidelines. These look at what the administrator of a defined contribution pension plan is supposed to do, both at a granular level and really what does the standard of care mean in the context of a DC pension plan. And they operationalize those and extend them to other sponsored defined contribution plans with member-directed investments. And that was largely a common sense articulation. In 2024, of course, lots has changed in 20 years, and there are more types of plans like TFSAs and first home savings accounts. And there are also more types of plan sponsors. Most notably, they've included financial institutions that sponsor certain types of plans as being sponsors. And for those of you who are employer sponsors, I think the key to recognize is that what they're describing as sponsor obligations are really things that you're going to want to talk to your service providers about. Most notably, they are focused on education and communication. Pension legislation is drafted mostly for defined benefit plans in which members don't really have to engage with the plan in the same way that DC members do. And in particular, CAPS is interested in members understanding having some idea of what they might get at the end of the day out of a retirement-focused plan, which I think makes sense, notwithstanding the various difficulties that can arise with projections. They also want periodic review of communications and education strategy. In other words, it's not a static one and done in the way that, say, an employee booklet might be. Moving to the governance framework, CAPSA wants every CAP plan to have a governance framework and also a review of documents program. I'm running out of time, except to say that the focus on member-paid fees is considerable because they want members to understand the impact of fees, and they also want U.S. sponsors to focus on value, reasonableness, and competitiveness. Now, some of you who don't have pension plans will say, well, why should I bother complying with this? If you have a DC pension plan, you're at your peril. This is the regulator's consensus view. If you don't have a DC pension plan, but you have another type of CAP plan, you're looking at, here's a statement of community best practice. If there is a claim against you, you're going to be assessed against the CAP guidelines. So how much risk do you want to take? And finally, the CAPSA risk management guidelines. Risk management is a longstanding part of good governance, so this isn't entirely new. What's interesting is that the guidelines add some new areas, most notably cyber, ESG, including climate risk, and leverage at either the plan or the investment level. CAPSA, of course, wants you to understand and mitigate your risks, but they are looking for plans to have a risk management framework that identifies, evaluates, manages, and monitors risks. And with that, and I'm out of time, I will turn it over to my excellent colleague, Michael. Thank you.
Thanks, Ross. Just sort of rounding out the regulatory changes, we typically look for trends as to what regulators are doing around the country when we present these kind of year-end wrap-ups. And the one thing that perhaps we anticipated a lot was more commentary on ESG. That's the way in terms of pension plan investing, and that's the way it was sort of trending. But it's actually been relatively quiet, other than what Ross just mentioned in terms of the CAPSA risk management guideline and one issue that my Quebec colleagues will address. But it's been a little quieter than we thought on that front. But one issue that I do want to draw your attention to that is on the radar of all regulators, to the point that a number have issued guidance on it, is the question of cybersecurity, a very critical issue for pension plans, and for that matter, for group benefit plans, in the sense that there are huge volumes of personal data that are at stake and subject to ransomware, hacking, and so on. And to that end, OSFI issued some guidance in early last year. They published their integrity and security guideline, which sets out expectations for financial institution integrity and security in various areas with some phased-in effective dates. Just waiting for the next slide here. There we go. In Ontario, FSRA issued some guidance as well in April. And most of these guidances are relatively similar in terms of content. Ontario neatly lays out its 7 practices for effective IT risk management on governance, data management, incident preparedness, and importantly, that last one, notification of material IT risk incidents. And lastly, BC, the Financial Services Authority there, issued its, actually updated its own information security guideline. They sought public commentary, which closed. BC was actually the first to issue guidance in this area. And interestingly, I mean, in our practices, we all in this group spend a lot of time with our clients negotiating service provider agreements with third-party administrators, fund holders, etc. And, in the past, some of the things we would negotiate were perhaps hypothetical, but there for belt and suspenders legal protection. But in terms of cybersecurity, this is something that's incredibly important. Certainly, we've seen that many of our multinational clients have standard cybersecurity addenda that they want included in these agreements, often 2 or 3 pages. And interestingly, we're finding that most of the providers are accommodating them because they're at risk as well. You might be haggling over the number of hours, say, 48 versus 72 for notification of incidents and things like that. But for the most part, they're being accepted, and it's something that's extremely important. So let's move on to some case law. Normally, I would have this slide sort of after the cases, but the way we've set it up today, I'm going to start with it in terms of trends and legal issues to watch. Surplus has been relatively quiet for a long, long time. There used to be massive amounts of litigation over surplus, and a lot of that shaped many of our issues that we deal with today in terms of contribution holidays, payment of plan expenses, and so on. But surpluses really didn't exist for a long time, but now they're back, and a lot of plans and their sponsors are deciding how best to deal with that surplus. So we expect to see cases starting to arise again as there are disputes over ownership between members and plan sponsors, likely or many cases with regulatory involvement, union involvement, and so on. Speaking of which, collective bargaining issues, we're seeing a much heavier presence and interest on the part of unions when it comes to pensions. They're very much back on their radar, and we're seeing to some degree a desire for joint governance from unions in the operation of especially defined benefit plans. Administration issues, always there. First one we're going to talk about, failure, I will in a moment, failure to enroll. We see a lot of situations with members coming out of the woodwork, seeking pensions many years after they've left employment, often decades when records are hard to come by. Spousal and beneficiary entitlements, contribution errors, of course, and plan changes. All those sort of day-to-day issues can pop up at any time and result in litigation. Human rights and charter challenges continue. I think there's a renewed interest in human rights issues in the pension context. And lastly, fiduciary duties and governance will continue to be issues in terms of how plans are operated, particularly where there is, for example, a board of trustees. There's certainly ongoing litigation in those areas. So I'm going to take a look at a couple of cases, and Carter will continue after me to expand that discussion. The first one I want to talk about is sort of a classic case of a failure to enroll in a pension plan. This was actually an arbitration involving a member in Saskatchewan, a plan member, and who started her employment in 2011. And at the time, she was told she was eligible to enroll in either the defined benefit or defined contribution plan. She had her choice. Those plans were sponsored by her employer. But it did say in that letter that if she chose not to enroll, she would have to sign something called a declaration of non-participation. And even if she failed to do that, if she didn't complete the declaration, then she was deemed to have completed it. So basically an acknowledgement that she was going to did not want to enroll in the pension plan. If she did nothing, that would be deemed to have been her answer. So in 2012, the organization sent her a pension package, which included a letter advising her of the pension and the option to buy back service to her eligibility date. So this was already a little bit after the start of her employment. They sent her copies of pension plan booklets and so on. And so she didn't respond to that. So they sent her another letter saying she would be deemed not to participate in either pension plan. as these things go, about 7 or 8 years later, she realized she was not a member of either plan, and she filed a grievance saying that this was essentially the employer's responsibility. They had breached the collective agreement, that there was a negligent misrepresentation, they hadn't really informed her properly, and so on. And the arbitrator dismissed the grievance. They said that under the defined benefit plan, the employer had to provide an explanation of the plan within 60 days after they became eligible. And while they were late, they did correct that. And despite the regulatory requirements in that regard. So they said that, the information they did send out back in 2012 met the requirements of the collective agreement and the Pension Benefits Act, and cured any breach by the employer. So they said that it was negligent, but they found there were no damages because they cured that failure and they gave her the package. And they did note that she was a very highly educated employee. She had completed other forms for benefits, group benefits, and things like that. So, the employer was lucky in this sense, but they had sort of done what they needed to do. But it's a very common situation where employers or employees fail to do something, and sometimes it goes the employer's way when there's a dispute, and other times, like in this, it did go the employer's way. A lot of times it goes the employee's way. And the important thing is that if you do see an error in that you remedy it as soon as possible. So one other case I want to talk about quickly, again, a sort of a common situation, happens from time to time. In this particular case, Citibank decided to wind up a part of their pension plan, and the Ontario regulator, noticed an error which affected the calculation of pension benefits for members who were either early retiring or deferred vested members. And historically, they've been treated equally in benefit calculations under this plan. And when the plan was restated in 2002, there was an error that was made that treated the groups differently, but nobody noticed until the regulator brought it to their attention. And so the only way to fix it, the only way to wind up the plan, was to seek what's called a rectification. In this case, the members were notified and didn't make any complaints. Oh, I'm having trouble moving this slide along. Andrea, if you can move it along for me, please. There we go. And basically, these are situations where nobody knew there was an error. The members didn't know, the employer didn't know, the people calculating benefits didn't know. So all that was really happening was the contract or the plan text was being brought into line with the intention at the time. And the court was satisfied here that Citibank never intended to change the way it calculated the pension benefits. And FSRA did not object to it as well. So it's not something that you can use and take advantage of all the time, but it is a situation that does come up in pension circumstances, and sometimes not for many years afterwards. So courts continue to be open to rectifying pension plan errors where the error does not reflect the intent of the sponsor. Now I'm going to turn it over to Carter to continue on with the case discussion. Thank you.
Thanks, Michael. So I'm going to be discussing 3 cases today. The first is called Goretzky and Bialechuk. So this case is a pensions case coming out of British Columbia, and it involves a pensioner named Mr. Goretzky, who had both a spouse and a common law partner. So the issue here was that both the spouse and the common law partner claimed entitlement to his joint survivor benefit. By way of background, Mr. Goretzky and his wife were married during a time in which he contributed to his pension plan. However, after he ceased his employment, he moved to Poland, where he lived with and purported to marry Miss Bialechuk. Now, it's important to note here that Mr. and Mrs. Goretzky were never in fact divorced. However, they were separated. So in 2012, Mr. Goretzky became eligible to commence his pension, at which time the administrator of the plan sent documentation to Mr. Goretzky, which identified his wife as a beneficiary. In response, Mr. Goretzky sent a declaration stating that Mrs. Bialechuk was in fact his common law partner and therefore should be the beneficiary. Upon receiving this declaration, the administrator issued a certificate of entitlement, which identified Ms. Bialechuk as the beneficiary of the benefit. Now, upon Mr. Goretzky's death, the administrator was prepared to pay the survivor benefit to Mrs. Bialechuk. However, Ms. Goretzky commenced a legal action claiming entitlement over the benefit. When the case was before the BC Supreme Court, they reviewed both pension and family legislation and determined that the definitions in the Pension Benefit Standards Act gave priority to Ms. Bailey-Achuk as the common law spouse. However, under the Family Law Act, Ms. Goretzky was entitled to half of the pension benefit when they were separated, even though it later vested with Ms. Bailey-Achuk. What we can take away from this case is that family law may override pensions legislation, particularly in the case of determining the entitlement of survivor benefits. It's important to note here that this case is not the only instance where we've seen court making such determinations. Back in 2023, we saw the Saskatchewan court do a very similar thing where an ex-spouse was entitled to 45% of the survivor benefit even after they were divorced. We've received disputes over the entitlement to joint and survivor benefits similar to this one continuing to be an ongoing issue. So the next case I'm going to discuss is Certainty Canada Inc. and Unifor Local 1256. So this is technically a benefits case, however, it does engage pensions legislation and pension interpretation. So this is an arbitration decision involving an employer who had a defined benefit plan and who was also subject to a collective agreement. By way of background, under the defined benefit plan, employees were able to take early retirement at age 55 and reduce their pension. Per the collective agreement, employees who retired were entitled to retirement benefits. So in other words, the employer would pay the full cost of premiums for extended healthcare benefits. The issue here arose when an employee stopped working at age 55, but deferred the payment of his pension until age 65. In response, the employer took the position that by deferring his pension payments, the employee had not retired, but had rather resigned. And therefore, the employee was no longer entitled to the retirement benefits under the collective agreement. The union disagreed and filed a grievance. They argued that the employee was entitled to benefits from age 55 to age 65. So the arbitrator ultimately concluded that the employee was entitled to these retirement benefits from age 55 to 65. And in reaching this conclusion, he made the following findings. So first, the collective agreement gave employees the right to retire at an early retirement date, but it didn't contain language to distinguish between employees who do and do not defer their pension. Further, the collective agreement does not specify whether or not employees who retire must start receiving their pension payments immediately after they stop working. The pension plan permitted early retirement, but did not differentiate between employees who do and do not defer their pension. So ultimately, this came down to an issue of interpretation between the collective agreement and the plan. So the takeaway here is that the interplay between plans and collective agreements and their interpretations continues to be an issue in pensions and benefits law. Issues of interpretation have been popping up all around. For example, in 2022, in the case of Williams and Air Canada, there was an issue as to whether or not an employee was entitled to make pension contributions during a notice period. And ultimately, this came down to an interpretation of the phrases termination of service and termination of employment. We expect that issues related to interpretation of pension plans, benefit plans, and collective agreements will continue to be an ongoing issue, particularly where those documents contain ambiguous language. So the final case I'm going to be discussing is Okanagan College and Okanagan College Faculty Association. So this is a benefits case, and it stems from an amendment to the BC Human Rights Code that eliminated mandatory retirement. Specifically, Section 13 of the code prohibits, among other things, the discrimination in employment on the basis of age. However, there is an exception in the case of a bona fide group insurance or employee insurance plan. Now, despite this amendment to the code, the unionized employees of Okanagan College continue to have their long-term disability policies terminated at age 65. The union grieved this termination, and the arbiter had to consider first whether or not the termination of the policy was a prima facie discrimination, and then whether or not terminating the policy the terminated policy qualified as a bona fide policy for Section 13 of the code. Turning first to whether or not there was prima facie discrimination, the arbiter noted that more and more union members were choosing to work past the age of 65. Ultimately, the arbiter held that the denial of long-term disability benefits after the age of 65 perpetuates disadvantage and fails to correspond to the actual circumstances of the employees. Based on the foregoing, the arbitrator concluded that the denial of long-term disability benefits after the age of 65 constituted prima facie discrimination. Turning to whether or not the policy was a bona fide plan, the arbitrator applied the test for a bona fide plan set out by the Supreme Court of Canada, which requires first there to be a legitimate plan, second, that plan to be adopted in good faith, and third, that the plan was not adopted for the purpose of defeating protected rights. The arbitrator concluded that the long-term disability plan was legitimate and adopted in good faith, but went on to question whether or not the policy was adopted for defeating rights. Based on the circumstances and the evidence before the arbitrator, he found that the employer could not have reasonably believed that the plan was not adopted to defeat protected rights, and therefore it was not a bona fide plan under the code. The arbitrator did acknowledge that the employer may have initially believed that there was an additional cost associated with providing those long-term disability benefits to individuals over the age of 65. However, evidence shows that that cost would not have been destabilizing to the company. Further, the arbitrator noted that the insurance industry is evolving and developing new products that could have provided long-term disability benefits to employees beyond the age of 65. So ultimately, the employer was ordered to take reasonable steps to amend the plan to include long-term disability benefits for employees aged 65 and over. And it was told it should consult with the union to maintain reasonable transparency in its decision-making process. So the takeaway here is that long-term disability policies that terminate at age 65 may not be a bona fide plan for the purposes of human rights legislation. And employers should be aware of this, particularly given that, as the arbitrator noted, employees are beginning to work past the age of 65, and that is becoming more and more common. Circling back to, similar to as Michael discussed, these are some of the benefits issues that we are currently watching and think are people should be aware of. So as Michael mentioned, human rights and charter challenges. This is what we just saw with the Okanagan case. These are continuing to be an issue, and employers should be alive to them. Second, as Michael mentioned, cybersecurity is an ongoing issue and something we need to be alive to. Plan and contract interpretation. This goes back to the CertainTeed case. Lack of language, ambiguous language, especially in between documents that are meant to work together in employment, can cause a lot of issues for employees and employers. And then collective bargaining issues is something to be alive to as well. I'm now going to turn it over to our Quebec colleagues, Dominique and Rhonda.
Hello, bonjour from Montreal. I'm going to be addressing with my colleague Rhonda the legislative changes in Quebec. For the purposes of the pension law, the Quebec Supplementary Pension Plans Act, the Voluntary Retirement Savings Plan Act, and our Quebec Pension Plan, the three statutes that are listed below, there's essentially Bill 80 that came into force on January 1st this year, 2025, and it is further to the budget presentation of last March of 2024. And the main, next slide, please. The main feature of Bill 80, of course, is the variable payment life pension question. Just to bring you back a few years, we know that in 2019, with the federal budget, and the federal government announced that it would be introducing this notion of variable payment lifetime pensions. And Quebec was quick to respond with already amendments in 2020 to the QSPPA, where we now allowed DC plans to offer members to give members the right to ask to receive a variable payment lifetime pension with their DC account balances. They could use those balances in whole or in part and ask to receive at retirement a variable payment life pension, or VPLs as we call them. So it was already introduced in 2020 in a broad form, and now what we see is that we're fine-tuning it and we're advancing more on this notion. So clearly, we have a province here who's favorable to these types of pension payments, and so it builds on what we did in 2020. Also, significantly in 2020, it's also interesting to note that we also allowed, as a buyout, any member of a pension plan, whether it be DC or DB, that has the right to receive a pension, could ask to receive either a lifetime variable payment pension or a temporary variable payment pension, but as a buyout, using either the commuted value or the account to buy themselves out of the plan. But now the feature that we're looking at is the DC plans, and that the DC plans must provide members with this type of pension. And also with the amendments, and now the DC pension plans must absolutely include in their assets one variable payment lifetime pension fund. That has to be included in the assets. Of course, a plan that offers this type of pension to its members. Next slide, please. So essentially, the amendment, what it does is that it allows the sponsor in the plan design to be more creative and to provide its own conditions for eligibility and timing for the payment of the VPLPs. Whereas in the past, under the previous formulation in the statute, it was only under conditions set by regulation. So now the sponsors themselves can define what the eligibility requirements are, what the conditions and timing are. And also in the amendments of Bill 80, it now is clear that it's only, there's a minimum prescribed age of 55. You can only make this request and obtain eventually a variable payment like pension if you're 55 or more, or unless the plan text is more permissible and allows you as of an earlier age. Again, that's in line with the general reform of allowing sponsors to be creative and determine themselves in their plan what the conditions are. Next slide, please. Another feature of Bill 80 with the VPLFs is that this fund has to be not only an asset of the plan, but it must be a segregated asset of the plan, of the DC plan. And the reform goes as far as to say that if there's a split in the plan, either because of a merger or because there's the separation of two companies, in which case the fund itself, the variable payment lifetime pension fund itself, is not severable. So it has to go either in one part or the other of the split when the assets are split. Also in Bill 80, we have regulations that have come in and that also sort of fine-tune essentially what the details of the reform I just indicated. So now we're still on the legislative front. I'll ask my colleague Rhonda to take over with Bill 77. Rhonda?
Next slide, please. Thank you. So I'll go ahead with a few other legislative and regulatory updates in Quebec. The first one, Bill 77, that I wanted to discuss. So this bill amends the Act respecting the pension plan of certain teachers, and the Act respecting the government and public employees retirement plan, which is known as the REGA, as we call it in Quebec. And the amendments to the bill now allow an employee to participate in the pension plan until December 30th of the year in which the employee reaches the age of 71. Previously, the legislations provided that the employees could participate in the plan up until the end of the year in which they turned 69. So this is a very recent update. The legislation came into force just this past January. Next slide, please. Following along, we have also a regulation that amended the regulation respecting the exemption of certain categories of pension plan from the application of the SPPA. So this regulation includes the following amendments. I should preface this by saying that in Quebec, by law, the administrator is the pension committee, which is separate from the employer, whereas, as we know, in Ontario and some of the other provinces, the employer is the administrator by law. So now this regulation in Quebec, amending the regulation, provides that following the amendment, the employer is permitted to act as the administrator, so long as the plan provides as such, when the plan has not more than 50 members and beneficiaries. Previously, the threshold to be exempt from forming a pension committee was only 26 members and beneficiaries. The other amendment to note under the regulation is that it provides that it will now be possible for the plan to be exempt from doing a financial report audit when the market value of the net assets of the plan is less than 5 million. And this is regardless of number of members and beneficiaries in the plan. Previously, the regulation provided that the plan could be exempt, but only in the first fiscal year if the market value of the net assets of the plan was less than 1 million, and if the plan had fewer than 50 members and beneficiaries. Next slide, please. Another change that we wanted to mention, or an update from Retraite Québec, is that they've released information on ESG factors in pension plans and findings of a survey of plan administrators relating to planned ESG actions. So among the survey findings, the data indicated that 30% of administrators surveyed had developed or updated a sustainable investment policy to include ESG factors. And among those without a sustainable investment policy, 26% plan to create one by next summer, and 31% cited insufficient knowledge as a barrier to considering ESG factors. So Retraite Québec is aiming to increase the rate of adoption of sustainable investment approaches by plan administrators from the 30% that we see in the survey to 50% by 2027. And we've released a plan d'action de développement durable that you can find on their website as well. It's available in French only. And the action that Retraite Québec is planning to take to achieve this is by adding a new question to the annual information return, the AIR, to track the progress of consideration of ESG factors. They're also going to release various information and training tools that will be developed regarding ESG factors. And they're also referring plan administrators to the guideline for risk management for plan administrators, guideline number 10 that was published by CAPSA last September that Ross and Michael had mentioned earlier in the presentation. Next slide, please. Yeah, and the next one, please, Andrea. Thank you. So the first case that out of Quebec that we wanted to discuss before I turn back to my colleague Dom is the Colorette and MC Commercial case. So this case concerned an application filed in 2021 to certify a class action against MC Commercial and its directors. This follows from a corporate reorganization that had taken place back in 2011. Under the corporate reorg in 2011, the Canadian economic activity of the original company, MAB Canada Inc., I hope I'm pronouncing that correctly, was split. So the sales were transferred to the new company, MC, along with the non-unionized employees who were also transferred. And then the pension plan for non-unionized employees and executive employees was also transferred to the new company, MC. Whereas the production stayed with MAB, the initial original company, as well as the industrial employees, which were unionized and consisted of most of the employees of MAB before the reorg. So they all remained with the original company. And of course, the pension plan for the unionized employees stayed with the original company, MAB, as well. Another fact to note is that the new company, MC, after the reorg, started buying the production of the original company, MAB, at cost. So the original company was able to continue operations for 3 years after the reorg until 2014, at which time I filed for bankruptcy. The final deficit of the pension plan was at that time over 35 million. And there was also a debt of 30 million, above 30 million actually, for the retiree social benefits. So this debt of combined 65 million fell under the liabilities of the bankruptcy. And that would obviously have a serious impact on the pension credits and the pension checks. Next slide, please. So the plaintiff of the class was alleging that the 2011 reorganization was conceived in bad faith in order to undermine the rights of the plan members under their pension plan and the rights to their social benefits. And they were alleging extra-contractual liability and abusive rights under the Articles of the Civil Code of Quebec. The Superior Court concluded that the facts alleged were sufficiently precise and concrete in order for the class action to be authorized, and it was authorized on 3 causes of action. Now, as a footnote here, the criteria to authorize a class action in Quebec are known to be quite lenient, so this doesn't quite constitute case law yet, but perhaps we'll get there as the case continues to follow its course. There was, following the certification of the class action, an application for leave to appeal at the Quebec Court of Appeal in March. Leave was denied, and so the case will now proceed to the trial where the plaintiffs will have to prove their allegations. Next slide, please. So some of the key legal questions and factual questions that will be addressed include the defendant's good faith and prudence in their actions, the impact of the defendant's relationship with the original company on its bankruptcy, and the defendant's conduct and its effect on the group members' pension and social benefits rights, as well as extra-contractual faults and abusive right and the entitlement to compensatory and punitive damages. Next slide, please. So it will be, as we follow this case, what will be interesting to note is whether MAB was actually able to contribute to the pension plan during the 3 years that it continued to operate after the reorganization. And here are their explanations for this 35 million deficit in the pension plan. And we think that the outcome of the case could significantly impact how pension plan deficits are handled in future in corporate transactions and corporate reorganizations. And now I'll turn it back over to Dom, who will proceed with the next case.
Thank you, Rhonda. I think we're a bit hard pressed for time, so I'll go quickly with this one. This is a case we discussed last year. We presented a bit of the merits. It's the constitutional case where the retirees it was held that the cities and towns of Quebec had violated the constitutional rights of retirees by de-indexing their pensions. There had been a special legislation in Quebec that allowed municipalities to suspend indexation as part of a pension reform, and that was struck down by the Quebec Court of Appeal. There was an application for leave to appeal to the Supreme Court of Canada, and in April of last year, April 11th actually, 2024, leave to appeal was denied. So now we're back on the ground, so to speak, and just so you know, we represent one of the parties in this case, so we really do have our ear to the ground. So we're back for another chapter, which is the remedy part of the thing. And so the saga continues, and the phase 2 is to determine what kind of remedy the retirees are entitled to for the violation of their constitutional rights. And for the moment, we're back in court, everybody, and just so everyone has a sense of the stakes, the whole amount of defendants in this case represent the cities and towns and municipalities of the province, represent all in all about 70% of the entire Quebec population. So, and we're dealing with 7 years of indexation that was unpaid. So for certain of the players, certain of the municipalities, we're talking about tens of millions of dollars of indexation to pay and with interest and et cetera. Next slide, please. So from the start, though, the cities and towns, the group has agreed to reinstate indexation as of this month, 2025, and to pay the capital, the retroactive accumulated indexation that was not paid over 7 years. So from 2017 to 2024, that's the period during which indexation was suspended. and that's been settled, and so the cities and towns are going to pay back the indexation. They're going to do it directly as opposed to through the pension fund, and I'll get back to that in a moment. But the first round of argument, which started in November, was about the interest and the starting date for the interest on those indexation payments. Next slide, please. Oh, I think you should step back here. But in anyway, and we're waiting for the first round. As I say, the first round of argument was about interest and the start date for paying the interest, and we're waiting for a decision on that. Now, the issues on the interest arguments, and we're waiting for, is who pays the interest, and as of when. So these issues are significant because we're taking into account that we're in a constitutional litigation where you have the Superior Court that's sitting under the remedial powers of the Canadian Constitution. So the issues are who pays the interest? Is it going to be the fund, or is it going to be the municipalities themselves directly? So we're in a context where the usual pension structures of rules, the tripartite concept of the sponsor, the trust fund or the pension fund, the members, etc. It's a bit subject to whatever the court can decide in terms of its constitutional authority to remedy a violation of rights. So there was a big debate as to, the pension plans didn't violate anybody's rights. It was the municipalities that suspended the indexation and so on and so forth. So, and there's a number of pension plans in the municipal world that do not allow or do not provide for interest on late pension payments. So that's also an issue that the court will have to deal with in this round. So we've got a lot of things at stake here. And in the meantime, we were waiting for Retraite Québec, the Quebec regulator, to actually get involved because of the upcoming round two. And the upcoming round two is once we've settled how much interest and as of which date, then becomes the question of how to fund the interest payments. And the most of the plaintiffs in this case are unions, and they're pushing for a fairly aggressive resolution whereby the cities would have to file retroactive actuarial valuations to cover that period from 2017 to 2024. And therefore would have to pay retroactively if there were any deficits that were retroactively created, would have to make special retroactive payments and et cetera. So we can understand that would be a complicated process. Or the alternative would be to take any liabilities resulting or any deficits resulting from the payment of the indexation and interest and roll them into the next actuarial valuations that are due for December 31st, 2024. And therefore, by rolling them into the next actuarial valuation, you could amortize any deficits in this regard in over the next 10 or 15 years. So that was a little bit that's the next round that's coming up. And we were waiting for the regulator, and it seems that on Friday, this last Friday afternoon, the Attorney General of Quebec informed the court that now the regulator has issued a guideline, and this is what I was reading, that the regulator seems to be, and I still have to study it more in detail, but it seems the impression that we're getting, especially on our side, is that the regulator seems to favor the roll into the next actuarial valuation theory, and that is going to suggest that the actuaries and the actuarial firms do that. And if that is the case, then it may impact on what the court will ultimately decide. Because at the same time, we're also suggesting to the court, very respectfully, that this is a matter for the regulator. So you see, there's a lot still to come in that case, and I'll leave you with that and send the mic back to Ross for the closing remarks.
Well, thank you, Dom, and thank you to our other speakers. We have some questions, and I'm going to take the first one, which concerns annuities, annuity buyouts and buy-ins, and in particular, whether the claim that was recently launched against Verizon in the United States, whether a similar claim could come to Canada. The short answer is, of course, yes. It's possible that the administrator of a pension plan that secures the benefits through purchasing an annuity, whether buy-in or buyout, could face a claim at some point, but for what? The Verizon claim is a little bit different than the other claims that have been made in the United States around annuity purchases. In particular, the prior cases have all involved insurance that's been placed, or an annuity that's been placed with one company, a company called Athene. And it seems that class action counsel, plaintiff side class action counsel, has a particular bugbear about Athene. Athene is owned by a private equity firm, and it reinsures its liabilities through a reinsurer that is a captive owned directly or indirectly by Athene. What's curious about the litigation is that there are no losses to date. Athene has been paying, and so it's not clear exactly what counsel is seeking in these. It's hard to imagine that a court would be willing to say that and then supervise the reversal of an annuity transaction. But I said Verizon is a little bit different. Verizon, first of all, does not involve Athene. The insurer at issue is Prudential, well-known, well-regarded American insurance company, and the claim is somewhat different. Again, it seems that the claimants are looking for some sort of guarantee that the insurer won't go under, and the practical issue is that given the regulation of insurance, particularly the way that it's regulated in Canada, if one were going to just place a bet as to whether your money is more secure in an insurance company or with any given employer, insurers in Canada tend to stay around for a very long time, and they're much more heavily regulated than are the pension funds of employer pension plans. So there's a very practical issue in terms of whether insurance company regulation is significantly tighter in Canada than it is in the United States. I'm not an insurance law expert, but my general sense is that it might be. But all that being said, it's not impossible for a claim to arise out of an annuity purchase. But there have been none so far in Canada. I'm not aware of any on the horizon. We'll take one more, which someone asked, and it's a very good fundamental question about the difference between a deferred profit sharing plan and an RRSP. And I say it's a good question because they look very similar. The member has an account balance. They invest it pursuant to the member's instructions, and they have an account balance at the end of the day. What's the difference? The underlying regulatory structure is entirely different. A deferred profit sharing plan is set up by the employer. The contributions are made only by the employer, and they are determined by reference to or out of the employer's profits. And a deferred profit sharing plan can only be funded through a trust. So there's structurally what it looks like. An RRSP, by comparison, is an individual plan issued by a financial institution or a trust company for the purchase ultimately of retirement income. The contract is issued to the individual, to the plan member. So a group RRSP essentially is a cluster of your individual RSP, mine, Michael's, Rhonda's, etc., and all administered under an umbrella agreement between typically your employer and the insurance company. And the fundamental difference is that in a DPSP, the member has an entitlement in a plan. In an RRSP, the member owns the assets in the plan. And we are at time. So I will say thank you to all of our viewers and our speakers for joining us today. And thank you as well to our behind the scenes folks, Andrea Houghton at Webcast Guru, and our own Andrea Tulloch and Mark Chatton. You'll see information on your screen for CPD credits for Ontario, Quebec, and British Columbia, and links have also been added to the audience chat. If you don't get a chance to claim your certificate today, they'll be sent out next week. Thank you again for coming, and from all of us, have a great day.